All rise.
Hearing the appeal of Queen on the application of Kevin Lewis against Redcar and Keating Borough Council and Persimmon Homes.
Yes, Mr. George. Could we just have a quick word about timing, just to be sure that we're all agreed about how we're to proceed? We have the whole of today, I think, and for perfectly understandable reasons, we're not sitting tomorrow afternoon. So I think the plan is we sit at 10 o'clock tomorrow morning until 1 o'clock. That's all right from your point of view, is it?
Yes, I'm most grateful.
And then we continue on Wednesday, but I hope we would be able to finish by about lunchtime on Wednesday. We'll see how we get on.
I think that may be ambitious. I think we may need the Wednesday, but we'll see how we go.
Well, we may sit a little earlier if there's a problem about it, but let's see how we go, as you say. Good.
Lords, in this matter, I appear for the appellant, Mr. Lewis, along with Maloney Juniors, Mr. Jeremy Pike and Mr. Kane Ormondroyd. Mr. George Lawrence appears along with Mr. Rodney Stewart-Smith for the first respondent, who's the registration authority, and Ms. Ross Crail appears for Persimmon, who are the development partner with the first respondent to develop the land. Lord, can I begin by expressing my personal gratitude to the court for accommodating me in the timetable tomorrow, and also thanking those in the Supreme Court office who've been incredibly helpful in relation to the logistics of this appeal, which has come on at shorter notice than usual. Lord, your Lordship should have the core volume, then a very small Appendix Volume 2, which contains a single witness statement, and then 5 bundles of authorities.
Yes.
And if I could just say a word about Volume 5 of the authorities, it consists of documents which, for the most part, are already in the other bundles. If I just take the documents in turn in Volume 5, 58 is a complete copy of Oxfordshire at first instance, because in the main bundle it was truncated, not the whole document. 59 is Beresford, because in the main bundle, Beresford is a little bit difficult to read. It didn't come out very well in the photocopying. So far as 60, the Common Schemes Regulations, that we've already put in the regulations, but your Lordships now have the scheme, which is part of those regulations, which was omitted previously. And 61 is an article by Pecci, which is in volume 4 at 54, but because it was on yellow paper, it didn't really reproduce very well, so it's better reproduced. There are going to be a few other matters which we'll add, and we've agreed a numbering with Mr. Lawrence, so I hope that will all work out very well. Can I, while I remember it, because my attention to this matter was drawn by Mr. Stewart-Smith, in the core volume at tab 12, page 278 and 279, your Lordships have the old Commons regulations. So it's the core volume, tab 12, page 278 and 279, and those 2 pages have been reversed. So that 278 should be 279, the other 278. I make no submissions on them at all, but I apologise to your Lordships, and I simply highlight that point before I forget it.
They seem to be all right in the appendix, actually. I don't have the core volume. I'm using the appendix, and it's appeared in the correct order. So
That's splendid. Now, your Lordships may have visited the baths of Caracalla in Rome. And you may recall that the Emperor Caracalla was the original hoodie, his name coming from the Gallic hooded tunic, which on some accounts he wore, hence the name, and other accounts he distributed widely to the Roman people, hence the name. His proper name was Marcus Aurelius Antoninus, and he was Roman Emperor from 198 AD until 217 AD, Additionally, with his father and his brother, then after his father's death with his brother Geta, G-E-T-A, and then he murdered his brother, as well as 20,000 of his brother's supporters, and ruled on his own. In volume 1, chapter 6 of Gibbon's Great History, which some of us had to do as a compulsory subject in history mods at Oxford, Gibbon, who praised to the sky Caracalla's predecessor, the Emperor Marcus Aurelius the philosopher, had nothing but bad things to say of Caracalla. He described him as a monster whose life disgraced human nature and whose reign accused the patience of the Romans. Now, your lordships may be saying, well, what on earth has got Caracalla got to do with this appeal? Well, somewhat surprisingly, this monster Caracalla seems to have played an important role in the history of the law of easements. For as I'm sure some of your lordships will recall from their study of Roman law, which for some was compulsory, it was Caracalla who in 211 to 212, during the consulate of Gentianus and Bassus, was the first, or among the first, to apply the principle of nec vi, nec clam, nec precario to the acquisition and recognition of servitudes by long, uninterrupted user. But we're not sure whether it was a letter or more likely a decree or a court order to one Calpurnia, and your lordships recall the Calpurnius Piso family. It was one of the great families, and Caesar's wife had been a Calpurnia, the one who failed to be above suspicion. But we're not quite sure who the Calpurnia was, but in a decree in 2011-2012, dealing with rights of light, and one assumes that he had a bureaucracy who dealt with these matters rather than dealing with himself. But anyhow, it's from Caracalla to Calpurnia. He declared that custom being observed for a long time takes the place of a servitude, provided the party who makes complaint does not hold possession by violence or clandestinely or under a precarious title. In other words, in the Latin, nec vi, nec clam, nec precario. And this is what, as my learned junior, Mr. Ormondroyd, discovered, found its way eventually, and in precisely the same terms, into Title 34 of the Code of Justinian. And nothing was said then or in the Code about any additional requirement that the right needed to appear to be claimed, any more than it did in the Praetorian prohibitory edict Uti Possidetis in relation to Usio Capian proper, to which we'll come in due course in Lord Blackburn's celebrated opinion in Dalton and Angus. I'm going to hold back that passage on Justinian until we get to Dalton and Angus, and then we can see it in its context.
Before we go further, Mr. George, is it common ground that the formula nec vi, nec clam, nec precario is satisfied here, and we're talking about an additional element? Yeah. It's accepted this is nec precario in this case.
As I understand, it has always been accepted that we are dealing with a case where, and we can go back and look at it, that it is a case which is which satisfies those three tests.
Yes, well, clam and v obviously don't appear here at all, but we will be discussing, I take it, what really is meant by precario.
My Lord, at the outset, I'd like to stress three things which I'd ask your lordships to keep in their mind throughout the argument, particularly on issue 1. One of them is a key principle, one is a major theme, and the third is what appears to be a significant concession by the first respondent in its case. The key principle is that of acquiescence. As the House of Lords repeatedly stated, acquiescence lies at the root of prescription, there being a public interest in recognising that which has gone on openly for many years and which could have, but has not been interrupted by the user. And in our submission, that's what Section 15 of the Commons Act 2006 is all about. Lord, the second matter I'd ask your lordships to bear in mind, I term the major theme, is the role of reasonableness and give and take in the relationship between owners of dominant and servient tenements. That there has to be, as Lord Hoffman put it in Oxfordshire, give and take on both sides. And this pervades the law of easements, and in particular it's a characteristic of the exercise of customary rights. And of course a valid custom always had to be a reasonable one. And we'll come to look at Fitch and Fitch in a little bit later, but it's the principle which explains why, certainly in my own 35 years of experience in advising in relation to village greens, I've never been asked to advise in relation to a dispute between the owner of the land and the inhabitants. The parties just get on with one another by mutual accommodation. Your lordships may know various people who are in the happy position of being the owner of the village green, and they make arrangements to have their private cricket match and so forth on the village green, and it's all simply done by negotiation and give and take between the people. Similarly,
one can think of many examples of give and take in the ordinary law of easements, surely, where the landowner, for example, is somebody who rides his horse out every day and rides it down the track which the public use. If you're a wise user of the track, you'll step aside and let him go past. But he's not ordering you off. He's just simply, because horses like to do this, he's making his horse go forward. And in this case, it's really a dispute between the golfers and the people who walked across the ground, or was it just simply that they were being polite to each other and making sure the game could continue and walkers not be hurt and so on?
Well, the latter, as you will know, our submission is that there wasn't a dispute. There was simply gentlemanly good behaviour and good sense shown by the people, in exactly the same as when I go for a walk in Knoll Park on the public footpath past which runs straight across the golf course, and it never occurs to me to say, I've got a right, I'm jolly well going to walk in front of someone when he's playing his shot. In the first place, it adds to my enjoyment of my walk or my run to pause and see whether he does a good shot or a bad shot. But secondly, if I were to go on, he mightn't be gentlemanly enough to stop his stroke in full swing, and I might get hit. But all this is simply an example of give and take. Just for the time being, I'll come back to the authorities on it and so forth. Time being, I just want to leave that in your lordships, that it is a major theme through customs and easements.
Yes.
Lord, the third matter is what appears to be a significant concession by the first respondent, because it now seems to be an important part of the first respondent's case that the inhabitants were asserting a right, albeit it's what the first respondent describes as a lesser right. I'm referring to the first respondent's case at paragraph 24, refers to, he says it's not enough to assert merely a lesser right. So an acceptance that a right of some sort was being asserted, and an acceptance in paragraph 87 that limited user was being acquiesced in. And as we come back later again to look at the matter, but we just want to put in your lordship's mind at the outset here that some sort of right is being asserted, some sort of right is being acquiesced in. The paragraphs were 24 and 87. Now, on the facts as found by the inspector, of course, the local inhabitants were present day in, day out, literally in their hundreds on the application site. This is not like the position on most golf courses.
Can we actually have a better view of this course than the single rather unhelpful piece of paper at tab 11. And I mean, that's got various numbers on it, which I assume show photographs, where photographs were taken. But for the life of me, I can't understand why we haven't got them.
Well, my lords, your lordships always know there's always this problem with plans and photographs, and that some judges say, why are we going into plans and photographs? We don't need them. But lords, I was going to come to this in a moment, but lords, just to help your lordship, near where point 5 is on that plan, which is, this is at tab 11, near where 5 is,
the clubhouse or something?
one tees off and drives on the plane across to the left towards 8. And that is the first hole of the course. And at the top, or towards the higher up on the top of the page, starting on the left, one starts on the 18th hole and one drives back towards the clubhouse and goes and has one's glass of beer or whatever it is in the clubhouse at the end. And there's a significant area of rough land both to the north and south of the first hole and to the north and south of the last hole. In other words, the whole central area there is a... But also that's what you've got 2 holes in that area which is hatched of an 18-hole golf
Well, I
course.
mean, that we can easily gather, and we're told it's about 350 yards long and 150 yards wide. But I can't see why it's necessary actually to prevent us just glancing at it and seeing, what the rough looks like and all the rest of it.
Look, I'll take instructions this time and we'll see if we can get hold of some photographs. I confess that there haven't ever been any photographs at any stage in this matter hitherto, but Lord, we'll see what we can do on that.
And what's happened, I know it's all closed down as a golf, certainly that bit, but I mean, did the whole golf course pack up?
The
other 16 holes, I imagine they got a bit more land and completed.
I think the rest is still keeping going. It was always the land owned by the local authority. I believe the rest. I believe the rest is still operating as a golf course.
Yeah, but they won't have a 16-hole golf course, so they'll have bought a bit of land.
They'll have done some adjustment. And from 2003, that was 2002, and this land, meanwhile, the local people have continued to stream all over it, but there are now what are described as permissive notices up, which were erected in 2003, and so people can't acquire any rights under those.
So just to get the picture right, the clubhouse and the first and the last holes and the practice ground together have all been relocated. Is that right? So that we don't have any...
Yes, Lord.
Where
yes.
was the practice ground?
The practice ground was somewhere beside the clubhouse, I think.
I don't get any sort of very good impression. I follow how, like many of these courses near the coast, you go along the coast for 9 and back for 9. But I mean, precisely how it all works here would be helpful to see. And I don't quite see. This is north up the top, isn't it? This is the sea here is on the north of the land. Yeah.
You're right by the coast. And as your lordships may have seen, the activities in which the local people are involved aren't just the conventional village green activities. That's walking and dog walking. It includes football, golf, rounders, picnicking, egg rolling, kite flying, frisbee throwing. So a wide range of activities, including at least 2 people who gave evidence that they actually played the course, not as members of the golf club. They just played the course. When I say played the course, they played this bit of the land, because that was the only thing the inspector was interested in, what was going on this particular bit of the land.
This plan is dated July 2008, and presumably it's there for planning purposes rather than...
It came from part of the scheme which was put forward. Lord, also in the bundle there is the plan which went with the application, but it's actually, if anything, slightly less clear in being able to see because it's on an even smaller scale. But there is in the bundle the application plan itself, and that forms...
this is 108.
Page 108.
It's sick. But I mean, on the one we've been looking at, which is the only one that provides any help at all, I mean, are these are all houses as built, are there?
Yes, my lord, the houses your lordship sees there are existing, are all existing houses, and many of the people from those houses are the people who came onto and used this land for recreation for a very long period.
Where do the sands start? I mean, as I understand it, the yellow is not sand, but a caravan park.
Yes, and there was some evidence about that, and the inspector found that whilst there were a few people coming from the caravan park onto the land, they were a small number because he found precisely that the land was being used by the inhabitants of the locality, and in the last year it was being used by the neighbourhood within the locality because the administrative unit changed in 2002, I think it was, but that he was satisfied that being the requisite user by the inhabitants of the necessary locality or neighbourhood within a locality, and therefore it merely turned on the question of as of right. But for the time being, I was just highlighting what I describe as this.
Charles, I don't think all the yellow is caravan park.
Well,
it's jolly confusing on the plan.
My lord, my lord, so far as what the yellow is, I'm very happy to leave that to Mr. Lawrence in due course to explain exactly what it is, because all I'm concerned with, and all the inspector was concerned with, was a particular application site and whether it met the qualifications of to be registered as a village green.
I think the only map which gives us the big picture, and it's not very clear, is at page 108 of the bundle, because there it is possible to see, you see the application site hatched, and then to the left of that Cleveland golf links, and presumably the other 16 holes were, and maybe 18 holes now are, on that area.
Yes, so I think that's right.
But comparing, I found some help actually in one of the other ones. I don't want to take up time on this, but my impression is, if you look at 110, you see in the centre of the plan there, High Street West, but up the plan, above it, there's no parallel street. Whereas if you look at tab 11, there is now a parallel street. It's called Local Road Corridor, and there are houses that are not hatched, which I suspect are the new houses. And I may be wrong about this,
I
but
think well, do you know what the answer is?
anyway, don't let's waste too much time on the
It's
details.
off the appeal site, the Lordship, the Lords. We'll check that.
Yes.
Lord, I was just emphasising my third point.
Yes.
That because what we say is that if, and we don't agree it was a lesser right that was being asserted, the important thing is that the right was a right of a recreational nature, and we say it was being asserted as of right and was being acquiesced in. Now, my Lord, having flagged up those three matters, I want to turn to the legislative framework, and my Lord, we could follow this in either the core volume or in the appendix, starting at tab 12 at page 274, and if anyone is working in the appendix as opposed to the core volume, there's a slight complication, so it's better if one follows it in the core volume because the pages got out of order. If one starts with page 274, one has section 15 of the Commons Registration Act 2006. 15.1, any person can apply, and then the three routes. 15.2, where a significant number of the inhabitants have indulged for at least 20 years and continue to do so. 15.3, where they ceased to do so before the time of application, but after the commencement of this section, that's after April 2007. And the application is made within the period of 2 years, beginning with the cessation. And 15.4, where a significant number have indulged, ceased to do so before the commencement of this section, and the application is made within a period of 5 years. And I ought just to draw attention also to a third way by which land can become a village green. It's section 15.8, page 275, which is actually page 272 of the appendix. The owner of any land may apply to the Commons Registration Authority to register the land as a town or village green. So you've got 4 routes. The 4th route is, of course, a very good route for an owner who wants to stymie development, because he can dedicate a little bit of his land as a village green, and thereby, in effect, make it incredibly difficult to develop other land, which perhaps after his death he just wants it to remain undeveloped. Lords, this is the first case to come before the courts under the 2006 Act. As your lordships will know, 2 appeals came before the House of Lords under the 1965 Act in its original version, that was Sunningwell and Beresford, and 1 appeal, or the Oxfordshire case, came under the 1965 Act as amended by Section 98 of the Countryside and Rights of Way Act 2000. And, my lord, in the bundle at page 267, I've got, yes, at 267, your lordship can see the 1965 Act in its amended form, because the effect, as it was in Oxfordshire, where 22(1)A, capital A and B, had been added by the 2000 Act, which made it, which included the requirement at 1AA that the use continue or have ceased during a prescribed period, and no period was ever prescribed. Now we've got the specific periods actually appear in the text of the 2006 Act.
Going back to the routes, it doesn't look as though it matters for present purposes whether it's route 1, 2 or 3, because head A of each of the subsections is the same. But I understood from the written cases that this is a 4A case. Is that right?
The application was made under, as your lordship says, under 4, and has always been treated as under 4. In practice, my lord, I suspect that it ought to have been made under 15.2 because of the provision of 15.7b. Because 15.7b, provided you get your 20 years in, it then doesn't matter if a permission is granted.
Yes.
So I think strictly it probably should have been made under 15.2, saying that there'd been 20 years from 1983 to 2003, and that it didn't matter that thereafter there was the permissive use because the use was regarded as continuing. In fact, the application was made under 15.4, saying that because of the permissive use, we haven't been using it. Lord, it doesn't going to affect any of the issues which arise in the case. And looking at section 15, and as I say, it doesn't matter which provision we go to, one sees that first of all you've got a significant number of the inhabitants of a locality or any neighbourhood in a locality indulging in lawful sports and pastimes for 20 years. And
Sorry, Mr. I mean, it was under 4, you may well be right in saying better under 2, but the cessation was assumed to be what? By way of the 2003 notices?
It was the 2003 permissive notices, and those who are making the application thought, well, this can't be as of right thereafter because it's by permission. That was right under the old law, actually under 15.7b, provided you've got 20 years under your belt, the fact that a permission was then granted didn't prevent you making the application. You were treated as the use being continuing. So it happens that on the facts of this case, I think it should probably have been made under 15.2 because it was still continuing.
And then how long have you got to make it under 15.2?
Under 15.2,
Can you wait for 20 years?
You've simply got to be continuing at the time of the application.
I know, so even if it's 20 years after
Even
they...
if it's 20 years, provided you've got your 20 years under your belt,
Yes, I follow that.
then it can come at any stage.
Right.
Your Lordships will straight away see that many owners found the 2006 Act slightly alarming, not least the fact that as a result of 15.4, you can have claims being made certainly up to 2012 because of the 5-year provision in that section, 2012 being 5 years after April 2007, and the fact that many people had relied on their permissive notices, but they were, in fact, don't apply. But, Lords, what we say is that of the feature, there's no dispute the significant number of inhabitants of the locality were on the land. There's no dispute that they were indulging in lawful sports and pastimes. There's no dispute they did so for a period of at least 20 years. So the only issue is the question as to whether it was as of right. And the inspector said that because of the deference to the golfers, it was not as of right, which is why we're here.
Yep.
My Lord, so far as the registration authority's decision, it was based on one case, which we'll be coming to in a moment, which is the Lang-Holmes case, which is volume 3, tab 31, and one sentence of obiter dicta by Lord Hoffman in the Oxfordshire case, paragraph 28. And we'll come back to those matters later. But certainly, Mr. Chapman, and we'll come to it, he says, you might think that it all being now as of right, that would be the end of the matter, but there's the Lang-Holmes case. So far as the relevant procedure, your Lordships will find that in tab 12, page 284, these are interim regulations. We're now on to further regulations, but this case arises under the interim arrangements regulations, which are at page 284. All I need to draw your Lordship's attention to is paragraph 6 on page 287, which, having provided for objections and so forth, says in Regulation 6, where an application has been made, as soon as possible, the registration authority must consider the application and any statements in objection, and then the registration authority must consider every statement and so forth. So that's Regulation 6. And then Regulation 9, where the registration authority has disposed of an application and has granted the application, it must give written notice. And 9.2, page 290, such a notice must include, where the registration authority has granted the application, details of the registration, and where it's rejected the application, the reasons for the rejection. I'll come back to that matter under issue 3 tomorrow morning. As I say, currently applications are made under a different set of regulations with slightly different procedures for the inquiry. Your Lordship is not concerned with those. Lord, can I then...
But it is still the case that the register does not state in any detail what rights have been established. It simply says it's a village green or a town green.
Then, Lord, while looking at the statutory framework, I think I should next take your Lordships to the Victorian statutes. They apply post-registration, and of course we say they can't determine the construction of section 15, as Lord Hoffman made plain in paragraph 57 of Oxfordshire. Your Lordships will find them at page 264 to 5 in tab 12. And an oddity of these statutes is that I think we've got a quite a large number of the members of what I may call the Village Green Bar here, certainly I've never, and I don't think any of us have ever come across a prosecution or an injunction being sought under these provisions, but they're in force and they apply to registered village greens. Now, so far as Section 12, that provides for a fine halfway down at level 1 on the standard scale, and that's now a £200 fine under the Criminal Justice Act 1982, a £200 fine for various activities which injure the village green or interrupt its use for exercise and recreation. But it's worth noting that the owner of the land has got a right to lead and drive his cattle or animals thereon. That's the 4th and 5th line, because it says, and without lawful authority. So the owner will have the lawful authority as owner to lead and drive his cattle or animal thereon. One presumes that the owner can manure his land, and that wouldn't fall within willfully manuring the land, because that looks as though that's aimed at third parties who intervene to damage the land. And the land can be fenced, because we can see in the 3rd line that it's a criminal offence to damage any fence. And of course, if it was going to have cattle or animals on, it would need fencing in order to prevent them getting off. So one can see straight away that one is envisaging what, of course, was always the historic village green, a bit of land which was used all or part of the year for farming activities by the owner, but actually could also be a village green because local people had acquired a custom of going on it and besporting themselves upon it. Your lordships will remember the Sunningwell case, where there were some horses which were grazing in Sunningwell. No one drew any particular attention to them. That's become a village green. One assumes that the owners, the diocesan board, are still putting horses on the land, but the answer is that provided there's give and take, you can still do your bird watching and walk your dog, despite the fact that there are horses on the land. But plainly, it's going to mean you've got to slightly adapt your play as to what you do, because plainly, if you see a group of horses or a group of cattle, you'd be very unwise to go over to there and start playing your game of football there. But again, it doesn't seem to have given rise to any practical problems in the past because of the concept of give and take. My Lord, if I then could ask your Lordship to turn the page to page 265, one's got section 29 of the Commons Act 1876. Now, the most important point of this was that individual inhabitants of the parish were able to bring proceedings, whereas under section 12, they had to be brought by the churchwarden or overseer or other person, as aforesaid. So now inhabitants can actually bring the proceedings, and one see that it prevents any encroachment or enclosure of a town of village green. I think enclosures there in the sense which enclosure acts were, where you enclose land and then build on it. That's what the enclosure acts were all about. Also, any erection thereon, or disturbance or interference with or occupation of the soil made otherwise than with a view to the better enjoyment of such town or village green or recreation ground shall be a public nuisance. But, my Lord, if the owner were to erect an electric fence and keep his cattle one side or his sheep upside, provided there's plenty of room for the inhabitants to engage in the sort of activities thereon, Lord, I think there'll be some difficulty in bringing a prosecution saying that that had been an erection or an enclosure. Again, it would all turn under the give and take principle, which is precisely the same, which your Lordship be aware, in the law of commons, where you can have lots of commoners who've got rights of grazing, but the owner can have his own flock of sheep grazing as well, as long as he leaves sufficient commonage for the commoners. So perhaps I should say sufficient herbage for the commoners, which they'll take as part of their commonage. But Lords, those are the two Victorian Acts. Lord Scott was of the firm view they didn't apply to a modern village green, but and Baroness Hale, I think, didn't express a view, but three of their lordships, including Lord Roger and Lord Walker and Lord Hoffman, held, and therefore it's now the law that those two provisions do apply to modern village greens. Of course, much depends upon the size of the land. If you've got literally a pocket handkerchief of a village green, and if it's the classic one, which is at the central triangle of a little village, well then plainly it's probably unfenced, and there's not much scope for animals unless you were to put on it a goat with a stake. Or you could put out a horse. They only put out a horse with a stake, but plainly you can't do terribly much, the owner, on that. On the other hand, you come to other bits of land, such as the area here, which is much, much bigger, or in Oxfordshire, Lords Rogers and Walkers will remember we looked at certain very, very large areas of land, and then there's much more scope for the owner to actually carry out activities whilst not interrupting the activities of the local people for their particular form of recreations. And the assumption is that no one's going to be bloody-minded. Because, I mean, plainly, if the local inhabitants say, right, we're going to erect 2 football pitches bang next door to one another, of course, they haven't got any right themselves to put up goalposts, but they could carry on goalposts, the sort people have in their back garden. But if they actually have it seek an exclusive use, and then say to the farmer, you can't have your handful of horses, which you always had, well, then that would be quite contrary to the principle of give and take, which one's always found governing these particular matters. Lord, the last matter I want to take you to on the legislation is to take you, please, to the 1899 Act. And, Lord, for this purpose, I'm going to ask that your lordships be passed a few supplementary pages which should be numbered as 41A, because your lordships have already got section 1 in volume 4 as tabbed 41, but your lordship really needs the other provisions of the Commons Act 1899. Starting point here is to go to section 15 on the 5th page, the page which has got page 5 at the top. In this part of the Act, commons shall include any village green. So this is one of these confusing acts where this includes a village green. And then section 1, power for the district council to make a scheme for regulation of commons. And your lordships will see that there's therefore provision also for bylaws, which is section 10, and therefore where you've got a landowner who is the district council, village green, the way is quite straightforward. The landowner district council makes a scheme. It's rather more complicated if the landowner is an independent person, because he can object to the scheme, and a scheme can only be made with his agreement. But here we're in the position of a case where the local authority are the owner, and they could make a scheme. And in the additional volume, volume 5, which was handed in, your lordships will find that there's a model scheme in the regulations dealing with the matters, and I don't need to take your lordships to the detail of it. Safe to say that some of your lordships may play golf at Huntercombe Golf Club, rather a fashionable golf club. That is subject to a scheme under the Commons Act of 1899. One can play very high quality golf, notwithstanding the fact that the local inhabitants are the beneficiaries of a scheme which entitles them to air, exercise and enjoyment and all lawful pastimes, on the golf course. How does it work? Answer given.
So Huntercombe is on the common, is it?
Huntercombe is on a common and is actually subject to a scheme under the 1899 Act. And there are many other Wimbledon Golf Club, two golf clubs which we refer to in our case. Two golf clubs play there, again on a common, and again in a situation where the inhabitants have got rights, and if you read their rights, they appear to have a right to stop the golf. But what in practice happens is there's power to set aside certain areas, and then there's simply a give and take. And very high-class golf is played there. So there is nothing at all unusual about having golf clubs coexisting with inhabitants and situations where the inhabitants actually have rights. Now, my Lord, I don't want to say anything more.
George, I mean, there was a joke, I assume it was a joke going around, that somebody objected to anybody playing golf sitting on this court. I imagine it was a joke. Did somebody ever suggest this?
I'm sorry.
There was to be an objection to any member of the court actually playing golf.
No, my Lord, there was no such objection because, my Lord, it was not thought that it would be possible to have a bench of your lordships which didn't have some golf players. Lord, what was indicated was that it would be better not to have, and we had no idea whether there was anyone who, so to speak, was a supreme golf fanatic, because, and I don't use the word fanatic in an abusive term, but someone who was an extremely keen golfer, because that might possibly give rise to. But Lord, we've always recognised that probably all of your lordships will occasionally play golf, and some of your lordships may play it with great skill.
So you're not asking us to declare
No,
our handicap?
Well,
no,
I played
for a minute.
without great skill, but with great enthusiasm. Is that supposed to
No.
disqualify? I
No,
regard that as a...
not at all.
No, but I regard it, if I may say so, as a so ill-judged an objection that I just want to put it on record. There may be some enthusiastic walkers in this tribunal. Would they be disqualified?
No, Lord, and there is no. Lord, against that statutory background, just 7 quick introductory remarks. First of all, public open space falls broadly into 3 categories. First of all, there's true public open space. That's land which is held by local authorities or some private landowners under statutory powers or trusts. And that includes local authority recreation grounds and public gardens. There are provisions in the legislation, section 123 of the Local Government Act 1972, whereby that land can be disposed of free of trusts, but, Lord, that land will never become a village green because people go on it by right, not as of right. Lord, the second category, public open space, are registered village greens over which a local section of the public have got rights to engage in lawful sports and pastimes. And that land you can sell, but the rights, it remains a village green, and in order to get rid of the village green rights, you have to go through a complicated procedure of supplying equivalent land which will be dedicated as a village green and which is as convenient for the local inhabitants. And your lordship readily see that it's very seldom that section 16 of the Commons Act, which is the section about replacement, comes into being, because not many people who want to develop a bit of land can find another bit of land which is going to be as convenient for those same local inhabitants. The third category is what we may call de facto public open space, areas of open land, usually within or on the edge of built-up areas where local people trespass and the owner does nothing to stop them. Now, the Commons Act 2006 is solely concerned with that third category. I say it's plainly not concerned, section 15, with true public open space, because people have got rights. There's no point in trying to register village green rights when you've already got rights, and you can't do it. And secondly, of course, it's not concerned with existing village greens. Second introductory point is that, of course, views can legitimately differ as to whether it's desirable or fair that so far as this third category, that's de facto public open space, after 20 years it should become registrable as a village green without any process of balancing the public interest as whether this is really desirable or whether the land might better be used for some other purpose. But well, the fact of the matter is that Parliament has 3 times decided in the last 50 years that such land should, subject to the 20 years user as of right, should become a village green. And that, of course, is what Sunningwell, Beresford and Oxfordshire were all about. Cases which I know Lord Walker found the last 2 cases a little troubling in some ways because they produced if I may put it this way, a slightly surprising result. In the last case, the Oxfordshire case, a bit of wasteland, which had been St John's College, Oxford's former waste tip, and which was in the local plan to be an affordable housing site, became a village green because local people went in there and engaged in, particularly in bird watching amongst the trees and in the boggy conditions. But that is what the law provides, and in the Oxfordshire case, their lordships were quite clear that this was in the public interest. This issue had first come up at the very end of Sunningwell in a passage in Lord Hoffman's speech at the end of Sunningwell, where he says much land has been acquired this way, the tolerance of local landowners allowing it to be dedicated to the public by acquiescence. And then in Oxfordshire, where a point was raised under Article 1 of the first protocol, the clear view expressed by their lordships that this was in the public interest. If it involved an interference with Article 1 of the first protocol, and there was a bit of the lordships were divided on whether it did, but even if it did, and Lord Scott said that it did, it was justified by the public interest in the preservation of open space after 20 years of user. And of course, the 2006 Act was enacted a few months after Oxfordshire, and actually certain provisions were slightly changed as a result of the Oxfordshire decision. Lord, thirdly, critics of the modern village green law sometimes complain that it's only when development proposals come forward that the inhabitants formally claim that it's a village green, and owners tend to cry foul when their planning application is met by an application to register it as a village green. But, my lord, of course, there's no cause for surprise there. The local inhabitants have got no reason to form action groups and engage in the quite daunting procedures of an application to register until the point comes when their right appears to be, when I say their right, their use appears to be threatened. And there's no particular reason, we would suggest, to be very sympathetic to the owners, because there's a relatively straightforward way in which any owner can prevent the recreational use becoming a prescriptive right. His easiest way, if he is perfectly happy for people to come on the land, is to post permissive notices, as was done on this land in 2003. Because thereafter, any use is precario, that's by permission. There's also case law which suggests that the landowner can post a prohibitory notice, a notice saying you are not allowed to come on this land, you are prohibited from coming on it. And in this case, the present case at first instance, Mr. Justice Sullivan, at paragraph 15, refers to the fact that in the Court of Appeal in the Oxfordshire case, Lord Justice Carnworth had said that such a prohibitory notice would be effective. And Lord, that's a sort of disputed area. It's a disputed area for 2 reasons. First of all, my Lord Walker in Beresford said that it was questionable. And secondly, because in Godmanchester, which we're going to come on to, Lord Hoffman, at paragraph 24 in Godmanchester, it's vol 3, tab 30, said that use in breach of a prohibitory notice would still be as of right. Lord, it doesn't arise in our case before your lordship. It's a matter which is going to be deserving of some quite careful argument in a case. Lord, my invitation to your lordships would be not to attempt to decide that matter once and for all.
We're not
now.
really concerned with this. I think I'm right in saying that Lincoln's Inn are rather careful about people passing through the inn, and there's notices there, but also entrances are closed from time to time to assert the right to do that. And that's another technique that can be adopted by saying people on Sundays can't come through or whatever it is. But we're not in that kind of case here at all, are we?
And the other simple way, of course, is to find one of these particular inhabitants, warn him off,
Yes.
and if he doesn't stay off, is simply to seek an injunction against him in the county court. And that will put the frighteners on other inhabitants as well. So that the owner's got a whole number of ways in which he can do it. He also can, of course, fence his land and simply keep people out by gates and so on. So there are a whole number of ways. All the law does is say is that if for 20 years you do nothing and enough people come onto your land to be to qualify the test in section 15, where you've got to be in significant numbers, then the doctrine of acquiescence will apply and the land will become a village green.
And that is where V and Clam and Precario come in, is it? Because he may protest that you're forcing yourself on the land, or you're doing it under cover of darkness, or whatever it is, and so on, and therefore you can't hold this against me.
Provided it isn't Clam, it'll be open.
Yes.
And that is the key provision. It's not very often you'll get Clam, but I've only had one case of Clam where the local girl guides used to go out at night and do night rambles on some fields. And they actually carried a lamp. So query, was that Clam? In fact, the case eventually was decided on, it was part of the Lang case, and it was decided on other grounds. It's the only case which I've ever come across of a proper Clam activity. Most village green rights, plainly, lawful sports and pastimes are best engaged in during daylight hours or perhaps early dusk. People may walk their dogs, but they're not going to be Clam. The key matter, though, is about net Clam, is that provided you are not net Clam, you will be open.
Yes.
And as soon as the use is open, the landowner is on notice. And a landowner, he doesn't have to be an ultra-conscientious landowner, he should be able to see that if people are going on in significant numbers, he should be able to see it, and then he can take the necessary steps to keep them off. But there is an awful warning to him. And if we could just go to, please, to volume 4 of the authorities at tab 53, and I just ask if there could be handed to your lordships also the document 53A, which we handed in earlier. It simply gives the next few pages of this extract from McGarry and Wade. And if we start with tab 53 at the bottom of page 1261, first of all, one has a quotation from Dalton and Angus, and then the last two lines. The message for a landowner who wishes to ensure that prescriptive rights are not acquired over his land is that a failure to act can be fatal, and he must not, therefore, suffer in silence. Moving on to 53A, consent isn't a synonym for acquiescence, but almost its antithesis. The former negatives user as of right, was the latter's an essential ingredient, or prescription by user as of right. And generally, I think, up and down the country, landowners are beginning to be aware of this, but it is fair to say that your lordship's judgments in Sunningwell and Beresford acted as a bit of a warning to various landowners who hadn't hitherto appreciated the significance of the doctrine of acquiescence. Well, Lord, that was my third introductory point. The fourth is that the legislative policy of successive governments with strong parliamentary backing has been to make it easier rather than more difficult to register village greens. And this is, again, it's rather surprising, but that is what has happened. Prior to 1965, of course, there was no register. That was the breakthrough under the Commons Registration Act, that there would be a register and a clear procedure for registering a new village green. Then come 2000, under the Countryside and Rights of Way Act, Parliament again made it easier by saying that the Secretary of State could prescribe a period when the use could have stopped. A period, what was always had in mind, was a 2-year period. Because what tended to happen was that the villagers spotted development was coming, they got their action group together, word leaked out, and the owner put up a fence or something, and so they weren't continuing until the date of the application. But the Countryside and Rights of Way Act 2000 gave the Secretary of State this power to specify a period in which it didn't matter if you weren't using the land. And also, previously there was some argument as to what was meant by inhabitants of a locality, and in 2000 it was added that it was enough if you were the inhabitants of a neighbourhood within a locality. Because it was rather absurd. Sometimes the only locality you could find was the whole county as a whole. And then it was said, but you're not really using this land as inhabitants of the county. You haven't got people from all over the county. Now all you've got to have is a neighbourhood within a locality. And according to Lord Hoffman, Oberture and Oxfordshire, it doesn't matter if the neighbourhood crosses the boundary of 2 localities. The great thing is that that you're within a neighbourhood or several neighbourhoods. But again, it was an attempt to make it a bit easier to register it. And then we get to the 2006 Act, where, and in general, I'd say lawyers were critical of the way village green law was developing. They thought landowners should be protected. But the 2006 Act is a great triumph, really, for the Open Spaces Society, because with very little opposition, certainly I've read most of the debates, with remarkably little opposition, actually you get not only the 2-year principle put clearly into the Act in section 15.3, but you get this 5-year provision in section 15.4, and the old device of putting up a permissive notice, even after 20 years, is stopped up, because if you've got your 20 years in before, section 15.7b says that won't work. And previously, people used to say, but there was foot and mouth for 2 months in 2001, so you didn't go on the land then. And so you didn't have your continuous use. And Parliament said, no, we're not going to have that one. And so they put in 15.7a, so the statutory notice period of when you're not using it because of a statutory notice doesn't apply. So a whole number of ways in which the 2006 Act makes the procedure rather easier. My Lord, the next separate point is just to remind yourselves of Sunningwell, Beresford and Oxfordshire. We're going to come to them in their detail in a moment, but they made it much easier, because up till Sunningwell, there was the heresy that the users had to believe they were exercising a right. That was swept away by Sunningwell, and it was held that the beliefs of the users were irrelevant. Of course, that was absolutely logical, because any lawyer would have known that he hadn't got a right to be on the land. He was a trespasser. And then in Beresford, the ambit of implied permission was made very narrow. To be an implied permission, there had to be overt acts of the landowner communicating a permission. And on the facts of Beresford, notwithstanding the fact that the local authority owner had laid out a playing field, provided benches, and allowed a football tournament, a Sunday football league, to take part there, held that wasn't enough to be an implied consent, and the land was registered as a village green. And then in the Oxfordshire case, again, that makes it clear in the very strong obiter that the ambit is very wide. You're not concerned just with grassy land, it can be any land, and that the procedures are to be applied in a very flexible way. So that's my fifth preliminary point. Sixth preliminary point is that up and down the country there are village green inquiries being held. In most cases, the public inquiry is held before an inspector who is either a barrister or sometimes is a local solicitor or sometimes nowadays is a planning inspector called in to do the job. Here's the evidence of the local inhabitants about their user. There's cross-examination and so forth in the ordinary way. Here's the objectors and their witnesses, and then makes a report. And as a result of the Lang-Holmes case, and more particularly of the Court of Appeal's decision in Lewis, your lordships can imagine the trend in the questions and the submissions from the objectors, which is to the effect, but you never interfered with the landowner, did you? And indeed, if the landowner came on the land, you got out of his way, didn't you? Did you ever see the landowner? Yes, he came on with his tractor. And would you have stood aside and let the tractor go past? Yes, of course I would have done. So you would have adjusted yourself, wouldn't you, to the landowner's rights? Yes, submission then made on the basis of Lewis in the Court of Appeal that whatever was being done on the land, it wasn't being done as of right because the inhabitants were deferring to the landowner. So this is very much a live issue. I mean, if the Court of Appeal is right, so be it. But I mean, it's a live issue up and down the country, and certainly I and my learned juniors know of at least half a dozen inquiries in the last year where the argument has turned on this question of adjustment. Last of these preliminary points. It's just to draw a distinction between what I call the shared user cases and the non-shared user cases. This is plainly a shared user case, just as Sunningwell was a shared user case where the owner is doing something positive on the land as well as the inhabitants. There are other cases such as Beresford, or most particularly Oxfordshire, where the owner was doing absolutely nothing on the land. It was being worked up as a development site through the planning system, as in Beresford.
Well, in Beresford, the local authority cut the grass.
They cut the grass and they got their plan, and as I say, they put on the benches, the seats. They'd originally provided the playing field, but all of that wasn't enough to constitute an implied permission. So you could therefore, it depends. Beresford is slightly difficult to know which category you put it into.
It doesn't strike me as an obvious example of a non-shared user case.
Well, Lord, I think Oxfordshire is perhaps the clearest case because there was absolutely nothing being done by the landowner in Oxfordshire. But plainly, in most of the cases which come up, in the 20 years, the landowner will have done something with his land. What's very frequently occurring at present is the case of the outlying field, which was never very profitable, but which was used for some purposes until set-aside came in, and then for a period each farmer got to set aside a percentage of the land. Plainly, he looked for his worst land to be set aside, and therefore you had a period where nothing was happening. Now the set-aside is gone and the common market's become rather more sensible, but that's been a frequent one up and down the country. But this issue with which your lordships are going to grapple under issue 1 as of right is equally applicable both to the shared use and the non-shared user cases, because does it matter how it appeared, or what appearance the users gave, or is it enough that their use is nec vi nec clam precario, i.e. open? And your lordships may have had the opportunity to glance in volume 4, page 55, at the article by Mr. Riddle, who's written a great deal on footpath and village green matters. And indeed, it was his article which Lord Hoffman said in Sunningwell that he had found so helpful in steering a way through the thickets of the wrongly decided cases about which said there had to be a belief. Now, in that article, and I come to it in detail later, but there's an amusing passage in which he envisages someone, a 20 years use for a footpath.
Are we given any clue as to who Mr. Riddle may be?
Mr. Riddle, no, I'm not sure whether he for years has been an advisor to the Open Space Society and the Ramblers, and he is the joint author of this book, which is called Rights of Way. But that book doesn't actually say, and I'm not in a. Oh, it is. What it says is here. I've got it here. He qualified as a barrister, and before his retirement was a senior lecturer in law in the University of Leeds. His books include Land Law, Jurisprudence, and the Law of Trusts. That's 3 books. He's vice president of the Open Spaces Society. So, Lord, I almost did him an injustice. But what he says, he gives the instance, and he calls it Miss Tompkins, who's his article which appears in a frightfully respectable journal, the Conveyancer. He calls his article Miss Tompkins, who decides to use a short cut across a field because she's got a slightly gammy leg. But she's a little bit nervous in the way she does it because of the owner, and slightly wondering what would the owner say if he were to see her. But she's not actually clam. She's not doing it secretly. She does it absolutely openly. But she manifestly looks extremely nervous, particularly during the first few years. Easier in the rest of the 20 years, because by then everyone's becoming more confident that nothing's going to happen and go across. And one of the points which Mr. Riddle makes is it seriously suggested that the inspector or the registration authority of footpaths has got really to concern themselves with the question as to what was the glint in the eye of the person? I mean, did they look as though they were a bit timorous, or did they look as though they were really determined? And it is only in the case of people who looked as though they were really determined and were stepping out that they can establish public footpaths or private rights of way, or is it enough that it be nec vi, nec clam, nec precaria? Well, now, Mr. Riddle has no doubt at all that there isn't this additional test, but I mentioned the matter at the outset because Your Lordship shouldn't think that this matter only applies in the area of village greens. But another example is, imagine a single carriageway track which leads up to the Great House, and it's got a couple of passing bays in it. And someone else who's got a house nearby starts using that track as an access to his own property. And he does this for 20 years. But occasionally, he does actually come face to face with the owner in his car. And he always, if he's got the opportunity himself, goes into the passing bay and waves past the owner, because frankly the track does belong to the owner. And he knows that he hasn't actually yet got his 20 years under his belt. He's hoping to get there, but it doesn't occur to him to drive up to the owner and say, "Come on, owner, into the passing bay. I'm going through." Now, if one applies the Court of Appeal judgment in Lewis, he's plainly deferred on these occasions by going into the passing bay, and there's no example where he's forced the owner into the passing bay, and he never acquires the benefit of a prescriptive right under the Prescription Act or under the doctrine of loss modern grant, insofar as that still survives. As I recollect, I think there are law commission proposals that should go, but I think it's still alive today. But this issue therefore arises in a variety of other circumstances, and certainly so far as we are aware, no one would ever have doubted that in the case I've just mentioned, be it Miss Tompkins or be it the person going up this drive and heading for the passing bay while the owner comes past, that those people at the end of 20 years would have established either a public or public right of way in the case of Miss Tompkins, or a private right of way in the case of the other instance. Of course, this is slightly different from the question as have there been enough people on the land. I mean, if it's going to be a public right-of-way, obviously there have got to be members of the public doing it, and a very few people doing it won't be enough for there to be the public use. The use has got to be the public. And that's dealt with in our case by saying that you've got to have this significant number of local inhabitants doing
Yes.
it.
Well, we
One or
don't
two
have that
isn't
problem
enough.
here, but if Miss Tompkins had been the only person using the route, then one wouldn't have thought it got within the area of a public.
Yeah, she would, if it was just her, she'd
You would
become a private right of way.
Yes.
And the problem is when you've only got, say, 5 people doing it, whether you've got, and of course, it would only become a private right of way if she'd got some land to which the easement could be
Yes.
pertinent to. Because private rights of way, like easements, have got to be attached to land. Public rights of way and village green rights are independent, freestanding rights. But your lordship is absolutely right. But in the public right-of-way cases, you've got to have enough people for it to be the public who are enjoying the right. And here, you've got to have enough people. But that's not a problem I face in this particular case, because on the inspector's findings, as I say, most days there were hundreds of local people out on the particular land which made up this particular application site. Lord, can I then come quickly to the background materials for the present case? As your lordships are aware, there are 2 applications to register. The first was March 2005. The second, in respect of exactly the same piece of land, June 2007. Your lordships are only concerned with the second application, but the only inquiry held was the inquiry in respect of the first application, and the same inspector, Mr. Chapman, who'd held the inquiry into the first application, advised in respect of the second application and did so in the context of what he'd found in respect of the first application. And therefore, they're plainly interlinked.
Yes.
And so far as the deference issue, that arises from the finding in the report on the first application, which is then carried forward. Lord, so far as the first application, I don't think I need to take your lordships to the application itself, but could I just take your lordships, please, to the main report, which we refer to as the 2006 report, which is in tab 8 at page 120. And your lordships may well have already read this. Your lordships will know there are very clear signposts in the headings as to what's happening. One starts with a description of the land on page 120. Page 122, we have details of the application. Then, starting at page 124, one has various passages from the evidence. And very helpfully, Mr. Chapman, at the end of each witness, tells one what he has believed and what he hasn't believed, and that therefore constitutes, in particular, findings of fact. Now, Lord, I don't propose to take your lordships through much of the oral evidence, but I want to take your lordships, please, to 6 passages. The first is Squadron Leader Kime at page 124. And he had, as we can see in paragraph 20, he knew the land in the past, but he'd moved nearby in 1981 and lived there till 2005. So he did his 20 years living there and using the land before the notices went up. And we can see in paragraph 20, sometimes he walked across the land, sometimes around it. Many other local adults and children use the land for activities such as dog walking and playing. Good summer days, 40 children, even in winter, 6 to 12 children each day, 20 local dog users, few problems with the golfers. If the golfers were playing a hole, people would wait for a few minutes while they played and then cross between shots or behind the ball. Out of the thousands of golfers, only about a dozen would tell people that they were not entitled to be on the golf course. There was one particular aggressive golfer who'd shout at people to keep off the golf course. The extent of use by local people hadn't really been affected by the fact that the golf club had stopped using it. That was in 2002 when the golf club stopped using it. They carried on. He believed that he and local users had a right to use the common, and it set out the basis of why he believed it. And then going on to paragraph 24, the inspector says, I found Squadron Leader Kime a man of very strong views, which he expressed forcefully. However, I found him basically to be an honest and reliable witness. I accept his evidence of his own use of the report land and his perception of use by other people. I have no doubt he did believe he had a right to use the report land, though in the absence of his title deeds or any papers relating to the young Stivey prosecution, I see no evidence he did have any such right. Indeed, I think the probability is that he did not. In the light of the evidence of other witnesses, I think it likely he was rather more vigorous in asserting to golfers the rights that he believed he had than he was prepared to concede. He seems to have been the only user of the report land who impressed himself on the golf club as a nuisance. Of course, whether someone's a nuisance or not is wholly irrelevant in these matters, but anyway, it's plain that he was one of the most forthright, and the inspector thought that he had been very vigorous in asserting his rights. If I could then take your lordships on to page 128.
I mean, if you're leaving Squadron Leader Kime, page 149, paragraph 136 is quite a useful bit. The last couple of sentences of 136, this is in Fletcher's evidence. The only person who caused trouble was Squadron Leader Kime, who claimed to own part of the land, let his dogs read numerous arguments with him, because he always said he had a right to be on the land. And then again with the next witness, Lupton, at 142, the only troublemaker, line 3, was Squadron Leader Kime. So he is a singular figure in all this. He's the only one who actually effectively was saying he, to the exclusion of the golfers, had the right.
And that I think is what Mr. Chapman is saying in paragraph 24 when he says he thinks in the light of the other evidence the Squadron Leader Kime was rather more vigorous in a sense.
He was, yes, but the real point is he was the only one who actually, on the evidence, as I understand it, contested the golfers' right to use
Well, I think that's right. Let's just look at some other passages. In the generality of what your lordship says is, I think, right. If I then just come to the bottom of page 128 and just pick up Frida Vivian Thomas, which is the bottom line of 128, and then going to paragraph 44, after her parents moved to the clubhouse, she learned to play golf and joined the golf club. She played 3 or 4 times a month on the golf course from the age of 12 until a couple of years ago. The golfers called the local people who used the common the dog walkers. It was sometimes frustrating when the dog walkers wandered across the golf course. You see, she's slightly in two camps, because she uses it for a time. She's actually living in the golf club and as a member of the golf club, and then she uses it as an inhabitant. So it was sometimes frustrating when the dog walkers walked around. There were occasions when families set up picnics in the middle of the first fairway and had to be asked to move for their safety. That's why I say this isn't like the ordinary golf club. I don't think anyone who's played Huntercombe's ever come across anyone actually setting up a picnic in the middle of the course. There have usually been a few people on the report land when she's played golf there, mostly children playing, people with dogs, and people just watching the golf. It was an unwritten rule of the golf club that local people had the right to use the land. There was never anything to prevent people from entering the report land. The only sign, other than the recent permissive sign she could remember, was a sign at the entrance saying Cleveland Golf Course, no through road. 45, she'd taken her children egg rolling, which involved rolling hard-boiled eggs down the dunes. 46, both while playing golf and playing with her children on the report land, she recognised some other users being customers from a shop, locally from Totem, and so forth. 47, now that she has retired, she walks her dog, and the inspector says, I found Mr. Thomas to be a good witness with a clear recall of what was happening. Then, if I come on to Catherine Alton, page 132, paragraph 64, she's retired here 21 years before 2005, and her garden had got a gate through. And at 64, this is Alton's evidence about the relationship between the golfers and recreation users was not wholly consistent. In her evidence in sheets, other users had priority, and that the golfers would stand back if she walked on the golf course. There was only one occasion when she'd been ordered off the golf course by a golfer. She told him that she had every right to be there, and later telephoned the secretary of the golf club to complain. He, that's the secretary, apologised profusely.
No, he accepted that.
So that's a clear case of acceptance that she's got, that she can go on the land. When cross-examined by Miss Crail, she said that at weekends there were golf competitions and she did respect those. At those times, the golfers didn't stand back. This is Alton's evidence that golfers generally gave way to other uses of Portland. It is out of line with the evidence of many other witnesses whose evidence I prefer on this point. However, I accept the rest of her evidence. So he is accepting the fact that when she was turfed off, she'd entered a complaint and been told, sorry, the person's been wrong to be turfed you off. So it's very difficult to say she isn't asserting a right. And then page 134, Julie Pink, 74, fourth line of 74, her use goes back to 1976 when the family moved to 113. Then if we go to paragraph 75, she tells us what she did, and she got a pony. She took the report there to eat grass, and about 20 other houses had similar back gates. No one ever complained about them. And then she and her friends used the land. They played ball games there. Her father and uncle were keen on fly fishing, practiced casting on the report land. She'd often taken her pony in hand to the back gate of her parents' house. Her husband plays golf and sometimes practices informally on the report land. Now, there's no suggestion he's doing that as a member of the golf club. He's just taking his golf clubs out and practicing informally on the report land. It was believed locally that local people had a right to take their horses on the commons to graze. She still had a horse and she was still using it. Paragraph 76. Relations between the golfers and local users was generally good. She took care to avoid busy golfing times. There'd been occasional shouts from golfers, get that bloody horse off the bloody golf course, to which she replied she'd every right to be on Cotham Common with her horse. She thought it was only twice she'd been shouted at by golfers. Once was when she was riding her pony across the report land in the 1970s, so that's out of our relevant 20-year period. The other time was about 15 years when her horse, which was nervous of going through gateways, came through the rear gate of 113 on a lunge rein like a lunatic. About 6 or 7, and one may feel it was quite perfectly right she was shouted at in those circumstances. About 6 to 7 years ago, there was a public meeting to discuss an issue, and I don't think that, and the golf club, and some complained that some golfers were discourteous towards other users of land. The club secretary apologised and said that if people reported incidents to him, he'd put a stop to it. Now, this is plainly the assertion of a right and an acceptance by the golfers that people, by the golf club, through their secretaries, she could carry on. And then 77 doesn't matter because that's about the area they came from. And 79, I accept Miss Pink's evidence. So there one's got that evidence. Then page 140, Peter Muse, and he'd been using the land primarily since 1994 when he moved to Redcar. That's the fourth line of 109. 110, he started using the report land when he lived in Church Street. He used it most days. He used to hit a golf ball up and down by the first fairway. There was some banter and a few nasty comments from the golfer, but he was never stopped. And then when he moved to Station Road, he walked on the report land at lunchtimes in the evening, and then he'd given up because of serious heart problems. And again, at 112, his evidence is accepted by the inspector. And the last of these extracts, Vera Duncan at page 141. And she's another of the people. She'd been a member of the golf club since 1955. And And she said there have always been children playing on the golf course. People from High Street West came out of the garden gates to walk their dogs on the golf course. There were occasionally problems with children or dogs picking up golf balls. There was a local rule that a ball could be lifted if its lie was obstructed by dog feces. However, it was generally understood by the golfers that local people had a right to be on the land. Golfers just shouted "for" if they got in the way. And then there's a slightly different issue about opening gates. Look at that. It may seem rather nasty, but plainly the golf club are being inconvenienced by dog turds. Frankly, the point is made. They're only dog turds because they're going on the golf course. It's plainly inconvenient to the golf club, but the golf club, far from putting up notices or prosecuting anyone, adopts a local rule that you can move your ball in those circumstances. So, and then the golf club secretary gives evidence, is reported at page 149. And this is an interesting passage. Paragraph 136. In his witness statement, Mr. Fletcher, who had been the member of the management committee and golf club secretary, in his witness statement, he gave the general impression that use of the report land by dog walkers and children wasn't extensive. However, in his oral evidence, a different picture appeared. He saw many, many people on the land. Literally hundreds of people, in inverted commas, walked dogs on the land. There were an awful lot of people, he said, have used the golf course. There was a lot of dog dirt on the course. However, people tended to keep to the side or to use the course when golf was not being played. Over the years, you got on nodding terms with users, and then he deals with where they came from, and then there's the passage, the only person who caused trouble was Squadron Leader Kime, who claimed to own part of the land and let his dogs relieve themselves on the course. Numerous arguments with Squadron Leader Kime, and then there's a passage dealing with the notices, with which your lordships aren't concerned, and then 139, Mr. Chapman writes, it was never satisfactorily explained why Mr. Fletcher's witness statement and his oral evidence differed so much about use of the report land by local people. Insofar as his oral evidence differed from his oral evidence, I strongly prefer Mr. Fletcher's oral evidence. Mr. Fletcher came over in his oral evidence as a very frank and genuine witness. Save for his oral evidence conflicted with his written evidence, I accept Mr. Fletcher's evidence. Then this led on to paragraphs which your lordships will probably already have read, which is page 157, when we come to the findings of fact.
Yes.
And 171, I won't read it, saying the golfers had used the land. 172, finding a fact that the land had been extensively used by non-golfers for general recreation activities. So that's 172, and then 175, the relationship generally cordial, evidence of only a few disputes, only squadron leader seems to have caused problems by actively asserting a right to use the report land. I'm not sure quite how that fits in with those two people who plainly had asserted a right to the golf club secretary and been told they got a right and received apologies, but there we are, and this may be because local people didn't materially interfere with the use of the land for playing golf. Many of the applicants' witnesses emphasised they wouldn't walk on the playing areas when play was in process. They'd wait until the play had passed or until they were waved across by the golfers. Where local people did inadvertently impede play, a shout of "for" would be enough to warn them to clear the course. I find that recreational use of the report land by local people overwhelmingly deferred to the golfing use. And that, of course, isn't something which I go behind at all. I perfectly well accept that, but what the legal consequence of that is what we come on to in particularly in issues 2 and 3.
Yes.
Then at page 159, there's the law. There's a section dealing with the law, and it's all very clearly set out. And then we come to page 161, where the legal issues are set out, and it's at page 164 that one comes to the question as of right, where Mr. Chapman is dealing with what are the ingredients, and he deals with nec v, nec precario, and in 193 he deals with what's meant by force, 194 with permission. Then can I ask your lordships particularly to note the first sentence of 195. It might be thought that in the light of the Sunningwell case, a conclusion that recreational user was not by force, stealth or permission would be determinative of the question whether such user has been as of right. However, the decision in Lang Holmes versus Buckinghamshire is authority that that is not the case. We're going to come to Lang a little bit later, and it's always been our case, and indeed Mr. Pike specifically pleaded it in the grounds of the original challenge, that Lang had been wrongly decided. And he then sets out some propositions from the Lang case, which I think the only significant one for present purposes is item proposition 6. Recreational user, which defers to agricultural user, is not as of right because it doesn't have the appearance to the landowner of the assertion of a right. Then, Lords, if we could move on to 212. Where we've got this in a section which begins at page 169, applying the law to the facts. At 212, he finds that it had been used, page 170, paragraph 212. He found that the land had been used for the period of more than 20 years. Then 213, it had been used by a significant number of people. 214, of the inhabitants of either a locality, or 215, of a neighbourhood within a locality. And 216, the uses had been lawful sports and pastimes. And we then come to as of right. And he found that it was nec v because of the notices erected in 1998. Now, your lordships may recall that we challenged that finding before Mr. Justice Sullivan. We succeeded before Mr. Justice Sullivan, and there's been no appeal against that holding. So that ground of nec v goes. Sorry, I should say that finding of v goes, and should be substituted by one of nec v.
Yes.
Then, so far as nec clam, in my judgment, recreational user had always been well known. And so far as nec precario, the only evidence he found of precario was the 2003 permissive notices. There's no other evidence of that, and of course we're relying on a 20 years before the permissive notices are erected.
Not limited recreational use.
Mr. Pike draws my attention back to 218. In my judgment, recreational user of Portland by local people had always been well known. So that's why what we say is that we're left now with the situation that it is nec v, it is nec clam, it is nec precario. Oh, well. Then he goes on 221, leaving aside the public footpath, I consider the reasoning in the Lang and Humphreys cases squarely applies to the report land in the present case. Use of the report land as a golf course by the Cleveland Golf Course would have been in breach of the 1857 and 1876 Act if the report land had been a town or village green. It was a use which conflicted with the use of the report land as a place for informal recreation by local people. It was not a use which was with a better view to the enjoyment by the report land as a town or village green. That's the first ground of his reasoning, which is called the Victorian Statutes ground, and that's disapproved by Lord Hoffman in Oxfordshire, and later, so far as our application, it's not decided on that ground. Then the second part of his ground was the overwhelming evidence was that informal recreational use of the report land deferred to its extensive use as a golf course by the Cleveland Golf Club. Accordingly, use was not as of right. And that's that second part of the reasoning, that there was overwhelming evidence that the informal recreational use deferred. That is carried through in all the other reports, which we'll come to in a moment, as the key element of the reasoning. Lord, the next stage is one gets Oxfordshire decided, and I'll come to Oxfordshire later, but historically, Oxfordshire intervenes at this moment, which we were arguing in March, I think it was, 2006, before their Lordship's house. And then we get to the further report, which is at page 176.
So we're now in June.
We move on to June, so we're post-Oxfordshire now.
Yes.
And Mr. Chapman is making a further report on the first application.
Yes.
And we can see at page 176 that the matter he's being asked is, can the council reopen the decision? And two, if so, should the decision be altered as incorrect in consequence of the Oxfordshire case? And various other questions. He says that he couldn't be reopened, it was raised judicator, so they can't reopen it. That's paragraph 2. But he then comes on, and the key paragraphs are at page 179 and 180, headed relationship between golf and other users. And what he says, and I take up the second paragraph under 3.2, as I understand Lord Hoffman's comments, he's identifying the need carefully to distinguish between two distinct points about the relationship between the use of land by the landowner or the local inhabitants. First, he disagrees with the views of Sullivan and Lang and of Judge Howarth in the Humphreys case that the fact that the landowner is carrying on activities during the 20-year period would be in breach of the Victorian statutes if the land had been agreed necessarily disqualified the land. He says the recreational activities of local inhabitants can create a new prescriptive green, that he, as Lord Hoffman, if in practice they're not inconsistent with the use of the land. Insofar as I relied on the Victorian statutes, in this part of my report, I was wrong according to Lord Hoffman's reasoning. However, second, Lord Hoffman says the use made of the land by the landowner may be relevant to the question whether the landowner would have regarded people using the land for sports and pastimes as doing so as of right. It seems to me this is the critical question on the facts of the present case. My finding of fact that recreational use by local people overwhelmingly deferred to golfing use, my conclusion was that such deferral precluded user as of right. My Lords, we do place some emphasis on the use of that word precluded. I'll come back earlier on, but it was plainly he thought that it was an automatic matter, that deference precludes user as of right. This is a conclusion which still seems to me to be correct and to be in accordance with the comments of Lord Hoffman. If local recreational users overwhelmingly deferred to golf use, they didn't have the appearance of asserting a right as against the landowner to use the land for recreation. And I come back to Miss Tompkins again and those sort of matters. Well, then there was the second application was made, and that was it was made on the 8th of June 2007. There were 5 applicants, including Mr. Lewis, who brings this challenge. Your Lordship can find it at page 88, and I ought just to identify it to your Lordships. Page 88 is where Mr. Lewis signs as supporting the application. And at page 90, your Lordship will see that they indicated that user as of right ended on August 2003. As I said, they were obviously not aware of 15.7b at the time, which is why they went under 15.4 rather than 15.2.
Yes.
Your Lordship can see that entrance, yes. August 2003 there. And then at page 101 to 2, this is Mr. Lewis, as your Lordship will see on 102, Mr. Lewis, this statement which accompanied the application, And he said, on the left-hand page at 101, 4 lines down, I always used the common, even when it was a golf club. People still walk there. I taught my children to ride my bikes there. We played football there. We sledged there. And then page 102, 5th line, the common is still well used, and so forth. On a daily basis, around 180 different people use the land. Now, Lord, it's fair to say that in supporting this application, the residents did make it clear that they allowed the golf to be played. And if I could ask your Lordship to go to page 234, tab 10, 234, we've got the questionnaires, and people always fill in questionnaires in support of these applications. And if your Lordship would go to page 234, this is a purely typical questionnaire, which a lot of people filled in. And
Is it typically unreadable?
well, no, so far as this passage, it won't be at all unreadable, Lord.
It is
There may be...
in the core volume.
Mr. Willis?
Oh, well, Lord, I'm sorry. I'm told it's much better in the appendix than in the core volume. I still...
Some of us have got the appendix in the core bundle.
Well, yes, your Lordship does, but the original appendix...
Yes, the original appendix is actually very clear.
It's very clear,
yes.
and it's one of those cases where when it's been further duplicated,
Right.
it's not absolutely clear. But Lord, it's a very simple point. If I could take your Lordship to question 7, page 234,
Yes.
the question typed is, have you been able to access the whole of the area, brackets, subject to noting the activity of golfers and avoiding them? Close brackets.
It's the same on 233.
And the same at question 7 on 233, where it may be slightly clearer, and the answer...
Oh, it's on 233, isn't a problem at all.
Right, it's
the
a
same
standard
question.
questionnaire,
Yes.
my Lord, and you see the answer given, yes. So an acceptance that they were noting the golfers and avoiding them, in other words, not going straight in front of play. And that is accepted in the questionnaires. And
The word deferring wasn't put to them. I don't know whether they would.
Absolutely.
They might have accepted. I don't know.
they noted it and they avoided the golfers.
Yes.
And I say that appears to accord with the evidence. And this then led on to a series of further reports, and we can take these again, I think, quite quickly. The first is at tab 8, page 184.
Now, we're in June 2007.
We're now
with
June
these fairly quick
2007,
response.
dealing with a second application.
Yes.
And Mr. Chapman goes to Mr. Chapman as to what they should do, and there's only 3 paragraphs, two paragraphs I need to take your Lordship to, and they're both at page 188. First is paragraph 9. It follows that the 2007 application is not defeated by the 2003 permissive notices, because the application was made within 5 years after the erection of these notices. Mr. Chapman didn't take any point on 15.7b, and I suspect that he, like I think we on our part, didn't appreciate the significance of 15.7b. However, the other 2 reasons for rejection of 2008 equally apply. The finding that it was not as of right because it deferred to the extensive uses of golf course, and the finding about the 1998 prohibitory signs. Your Lordships aren't concerned with the 1998 prohibitory signs, so he's simply saying that the not as of right. Note that he treats it straight, foursquare, as a matter of being not as of right. And then at paragraph 11, he says, I've seen an opinion of counsel in which the view was expressed that duly made refers only to procedural matters. However, I think the construction events context seems to me absurd if the registrar were obliged to publicise and process an application which was bound to fail on 2 of the same grounds as the 2005 application. Well, nothing turns on the duly made point. The fact is it was going on the deference point. There's then various further correspondence.
Well, paragraph 12, worth noticing, he doesn't see any point in further evidence because he thought the point had been fully covered.
And one can understand that because it went up, the period being relied on was up to 2003. He looked at that period. But the only point on evidence I suppose he might have said was, well, I wasn't previously concentrating on 1980, what was happening in 1982 to 85, but he looked at the matter broadly and it wasn't going to turn on that matter. Then there was various correspondence came in from the applicants, and I just draw attention at page 198 to a letter from Mr. Lewis's instructing solicitor and my instructing solicitor today, 10th of July 2007, 198, and the key paragraph is on page 199, and it's the paragraph begins, he describes. That's Mr. Chapman describes the first of these as the finding that recreation use wasn't of right because it deferred. Mr. Chapman QC's finding this matter predated the Oxfordshire case. It was held that Lang and Humphreys were both wrongly decided, as Lord Hoffman, with whom three of the other law lords agreed, observed. In practice, I think it was really, this was an obiter of Lord Hoffman. I don't think the other members of the Lordship expressed any views on this particular point. Furthermore, as a matter of fact, golf use didn't prevent non-golf use, and the inhabitants of the Cotham area carried on the recreational use as of right. So the matter referred back to Mr. Vivian Chapman, and we have his further opinion, which is at page 200. This is the 29th of July. And there's only one paragraph which is relevant, which is at paragraph 11 on page 204. Dealing says this issue, deferment was the subject of exhaustive evidence argument during the 6-day public inquiry into the first application, when I may say Mr. Lawrence and Miss Crail were involved arguing the case for the objectors. I considered the point very fully in my report, and further report I concluded that local recreational use of the application land overwhelmingly deferred, and this precluded, that same word, a finding that local recreational use was as of right. He then says the applicants had applied for permission for judicial review, but it had been refused, and he sets out what Mr. Justice Collins had said on a paper application in respect of that matter. There's then some further correspondence, including at page 206 to 208, a submission by one of the applicants, a Mr. Davis, who, towards the bottom of page 207, well, halfway down 207, has got a section on deference and makes the point that there were lots of people, hundreds of people, on the land, and he summarises his position at 208 in the section in summary. There was not and is not deference to golfers. And then the matter goes back to Mr. Chapman, and at page 210 we've got the second further opinion of Mr. Chapman, but at paragraph 2 is that he says that he adheres to his conclusions and recommendations. So nothing turns on that matter. And then there was some further materials came in, and we have a third further opinion, which is the 18th of October, which is page 216. And at paragraph 4, 3 lines from the bottom, he says the deferment issues apply equally to the second application.
Yes.
And then the matter goes to the committee on the 19th of October 2007, and they had before them a report which merely summarised the opinions, and you've got at page 220 the recommendation of the report. We haven't got the whole report. If any of your lordships want the whole report, we've got copies of it, but it's never been, I don't think that it doesn't add anything to it, one way or the other. And section 3, its recommendation was that the committee should reject the application to register the land for the reasons set out in leading counsel's opinion of, and then they're set out. And at 2.1, so that was the recommendation, and we've also got the minutes, which is at page 225 of the 19th of October. and Mr. Davis was allowed to address the meeting. I'm sorry, I've given the wrong page. It's 222. It starts. And the head of legal services gives a presentation. The member's attention is drawn to the various reports on page 223. Your Lordships will say two-thirds way down 223. Then at the top of page 224, Mr. Davis, as representative of the applicants, addresses the committee. And he says, two-thirds of the way down that page, Mr. Davis, that's dealing with signs, he continued by stating that deference hadn't been given to the golfers. And then in the middle of 225, Mr. Davis accepted that some members of the public had deferred to golfers. He also stated he'd deferred to them. He wouldn't throw his frisbee if golfers were taking their shot, and vice versa. There'd be mutual respect for each other, with the exception of ex-squadron leader Skyme. The persons who defaced the signs were one or two of the golfers. They'd gotten on with each other for 20, 30 to 60 years. Mr. Davis stated the golfers had been deferred to out of politeness, but in the main there was no deference in any way, shape or form. And then your Lordship sees the resolution at the bottom of the page, which was exactly in accordance with the recommendation on page 220. And at page 219, the 24th of October, one has got the letter to Mr. Davis telling him the reasons why it had been rejected. A judicial review claim was then put in, which your Lordships will find at tab 5, page 51, 18th of January 2008, and more important is the grounds which were put in at page 66. And for present purposes, all I need, I think, draw your Lordships all I think I need... I'm sorry, I've gone to the wrong document. I've gone to the summary grounds for resisting the claim. Yeah. What I should have gone to is the grounds for the claim, which is at page 57.
Tab 6.
And I want to take your Lordship to paragraph 13,
yeah,
where Mr. Chapman's analysis position, which relied on the decision of the High Court in Lang, was, in this respect, wrong in law. And then paragraph 15, Mr. Chapman's recommendation to the Council that the local inhabitants had deferred to golfers in their use. But as a matter of fact, such a finding fact doesn't require or indeed permit the conclusion. Now, the or indeed permit is our ground 1, doesn't require is our grounds 2 and 3, that conclusion. And neither Mr. Chapman nor his recommendation explains satisfactorily why the law required that the application be rejected in such circumstances. And Lang is challenged again. The matter then goes before Mr. Justice Sullivan, which is tab 4, and Mr. Justice Sullivan at paragraphs 22 to 23 allows the challenge on the signs point, saying that the signs have been purely telling people it was dangerous, hadn't been excluding them, but he rejected the challenge on the deference point, saying that it had been all give by the inhabitants and all take by the golfers. It wasn't a proper case of give and take. But if I could just take your Lordships to page 48 and 49, and I'm literally going to finish in 1 minute.
Yes.
At page 48, paragraph 62, Mr. Justice Sullivan, in dealing with the aftermath of his judgment, and various submissions have been made to him, at paragraph 62 on 48, I think deference is only in a sense, subject to whatever Lord Hoffman may have said in paragraph 57 of Oxfordshire, deference is judge-made law, judge-made by me, that's in Lang, therefore, and you might well say there's a real prospect of persuading the higher courts to change it. And then paragraph 72, Mr. Pike, I think it's appropriate to give you permission to appeal in this case. I accept the point that the decision is founded on the facts, but the implication of this fact depends very much on the correctness of the principle. It does seem to me that the ambit of the deference principle is something which isn't determined, and there's a real prospect of success. He proved wrong so far as he was right in his own judgment and wrong in saying that so far as the prospect turned out to be illusory because your lordships have in tab 2 the judgment of the Court of Appeal, and I come at a much later stage to analyse that. And Lord, I've achieved what I planned to do, to get through all the facts and so forth, and come on to the substantive issue 1 after.
Thank you very much. 2 o'clock.